Hi everybody, it's Andy and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to talk about California residential landlord-tenant law, specifically 30-day notices and 60-day notices. Now, this video came about because I noticed that a lot of landlords, get into the landlording business by just posting an ad on Craigslist. They don't really kind of research the full extent of what can go wrong. And I mean, to be fair, in the vast majority of cases, things don't go wrong. Most tenants are honest people, they pay their rent on time, they follow the rules, etc. So the typical landlord really doesn't need to know the full extent of what can go wrong. But the thing is, when problems do happen, though, most landlords don't really know what to do. There is no kind of credentialing exam, certificate, class, or anything like that you have to take before becoming a landlord. So, I mean, a lot of times, landlords just don't know what to do when things go wrong. So, to kind of complicate things, landlord law, or landlord-tenant law rather, in California for the residential side is not terribly complicated. But the thing is, there are a lot of rules, and each situation has its own set of rules, basically. So there are a lot of proverbial, I's that need to get dotted, T's that need to get crossed, and so on. And if you don't do that properly, then you run into problems when you take the case to court, etc. So from the landlord side, it definitely pays to actually do things rigorously, to be very detail-oriented. So research and getting up to speed on the requirements, the facts, the law, all that stuff is going to be essential. So that said, I do have some qualifications that I have to give. So this video is going to be residential landlord-tenant law only. Commercial stuff is similar, but there's a lot of differences also. This video is not going to cover commercial stuff. If you have a foreclosure situation, this video is not going to cover that as well. There are separate foreclosure rules. If you have a mobile home or a houseboat or anything that basically is not a brick and mortar house or apartment or something, there are separate rules for those. This video does not cover them. If you have any sort of Section 8 or government funding, government rules that apply to your situation, this video is not going to cover that either. Section 8, other types of federally funded housing, state funded housing, all of those have separate rules as well. So there's a lot of disclaimers, landlord-tenant law has very situation-specific rules, So the last kind of disclaimer I have to give is not specific to a situation, but the idea is that if you live in California in a county or city that has rent control or rental ordinances passed at the local level, this video will apply to you, but you also have to follow the state rules as well as the local kind of laws and rules, ordinances, things like that. The vast majority of cities and counties in California do not have rent control. However, there are big cities that do. San Francisco does, Oakland does, Berkeley does, for example. So the thing is, if you happen to live in a city that does, just remember this video is not the be-all, end-all. You have to follow this video as well as whatever your local ordinances and laws require. So anyway, that said, let's actually get started in the actual meat of the video, why you guys came here in the first place. So the question regarding 30 or 60-day notices a lot of times is, Andy, which one do I have to give if I'm the landlord, or alternatively from the tenant side, which one am I supposed to receive? So the 30 or 60-day notice kind of question, then the answer to that depends on the length of time that the tenant actually lived at the property. So the general rule is going to be, if the tenant lived there less than 1 year, not 1 year, but anything less than 1 year, then the law requires that they get a 30-day notice. And if the tenant lived there 1 year or more, then the law requires that they get a 60-day notice. And the law in question is going to be in California Civil Code section 1946.1. And the 60-day rule is going to be in subsection B, and the 30-day rule is going to be in subsection C. I'll go ahead and write those over here as well as put them down below and link them for you like I always do. So the kind of follow-on question that I get a lot of times, or the point of confusion that I see a lot, is how to actually give the notice. For whatever reason, I have no idea where this rumor started from. You cannot give the 30 or 60-day notice verbally. You cannot do it orally. You cannot put it in a voicemail. It has to be done in writing. And that's, if you're interested in the law on that, that's California Civil Code section 1946. Again, write it over here, paste it and link it down below. So earlier we were talking about 1946.1. This time it's just 1946 by itself. Like I said, you cannot give it orally, verbally, via voicemail, etc. A lot of times people will try to give a 30 or 60-day notice by text or by email. Now, obviously, a text or an email is in writing, so it doesn't, it satisfies the writing requirement. However, you have service problems there also. If you send somebody an email, that does not count as legal service. So the thing is, the same thing for a text. You text somebody, it does not count as legal service. I don't have a video on this yet, and I'll try to explain it really quickly here. When it comes to court documents, legal papers, in order to basically give those documents to the other party, you can't just hand it to them. Make sure that they get it in some way. You have to actually do it by specified procedures. So that's called legal service. So the thing is, if you are a landlord and you want to serve a 60-day notice or a 30-day notice, you have to basically use one of three ways. Number one, the most preferred way is to basically hand the document to them in person. They don't have to take it, but the thing is you have to at least try to hand it to them in person. If they don't take it, drop it at their feet, do something. But you have to at least make the attempt. Number two, if personal doesn't work, then you have to do substituted. And substituted basically is finding somebody at their home who is old enough and is mature enough to take the document. You ask them to take the document, hand it to the actual tenant. You also mail the tenant a copy. And if that doesn't work for some reason, you can do something called nailing and mailing, which basically involves you just taking the notice, taping it to the basically the front door, for example, of the rental property, stating that the tenancy is being terminated. They have 30 days, 60 days, whatever it is, to actually move out. And then for nailing and mailing, you have to mail a copy to the tenant's address as well. So if you send an email or send a text, it does not qualify or fulfill any of these criteria here. It's not a personal, it's not a substituted, it's not a nailing and mailing. Therefore, it is not valid. And if you are on the landlord side, you will run into very, very severe problems later on in court if you do not fulfill basic things like proper service of a 30-day notice, a 60-day notice, etc. So that is kind of what I'm going to stop with in this video. Later on I might shoot a video on service generally, but just remember, for a 30 or a 60, it depends on how long the tenant has been living there. And then when it comes to actually giving a 30 or a 60, verbally doesn't work, has to be in writing, and it has to be served either personally, substituted, or nailing and mailing. If you're the landlord and you don't do that, then you are going to run into problems later on if your case ever makes it to court. So again, hopefully that wasn't too confusing. This will be the first in hopefully a long series of videos. The landlord-tenant kind of space, at least for the residential side, is not terribly complicated, like I said, but a lot of people tend to struggle with it, both landlords and tenants. So there's a lot of confusion here that I personally think is unnecessary. So anyway, that's it. Hopefully it wasn't too confusing. Like, share, subscribe, comment, all that stuff. And I will talk to you guys next time. Thanks.